Hey, fellow future CAs, welcome to today's explainer. As a CA student myself, I know exactly how much the ICAI loves to test the buyback of securities with those tricky application-based questions. So today, we're going to crack the complex legal provisions of Sections 68, 69, and 70 of the Companies Act 2013. Our goal is to get absolutely exam-ready by breaking down these provisions step by step. Let's get into it. Let's dive right into our roadmap for today. We'll be covering the sources of buyback funds, limits and required authorizations, the debt-equity ratio, key timelines and compliances, strict buyback prohibitions, and finally, those common exam pitfalls you need to avoid. Section 1. Sources of buyback funds. Where does the money legally come from? So under Section 68, subsection 1, a company can only tap into 3 specific reservoirs of cash for a buyback. We're talking free reserves, the securities premium account, or the proceeds of the issue of any shares or other specified securities. But here is a massive trap the examiner absolutely loves to set for us. A buyback can literally never be made out of the proceeds of an earlier issue of the exact same kind of shares. Keep that exception locked in your brain for case study questions. Section 2. Limits and required authorizations. Who approves what? What's really fascinating here is how the Companies Act scales the required approvals based entirely on the math. For a smaller buyback, meaning 10% or less of the total paid-up equity capital plus free reserves, a simple board resolution passed at a board meeting is totally fine. But the very second you cross that 10% threshold, the board loses that solo power. You absolutely have to pass a special resolution in a general meeting of the shareholders. Now you've got to cement this formula in your mind for the exam. The absolute legal ceiling for a buyback in any single financial year is strictly capped at 25%. If we're talking equity shares, it's 25% of the total paid-up equity capital. Overarchingly, the amount just cannot exceed 25% of the aggregate of paid-up capital and free reserves. It doesn't matter what resolution you pass, you simply cannot legally take a bigger slice than 25% in one financial year. Moving on to Section 3, the debt-equity ratio. Testing post-buyback solvency. Okay, the magic number here is 2. After a buyback is completely finalized, the ratio of the company's aggregate debts, and that means both secured and unsecured, cannot exceed twice its paid-up capital and free reserves. So the debt-to-equity ratio maxes out at 2-to-1. Why? Well, it's to make sure creditors aren't left holding the bag if things go sideways. If a buyback pushes that ratio any higher, it's a no-go legally. Section 4. Key timelines and compliances. Strict deadlines to memorize. Let's jump into the execution phase. You'll want to group these mnemonically for your MCQs. First, once the buyback is done, you have exactly 7 days to extinguish and physically destroy those bought back shares. Then, within 30 days, you've got to file a return of buyback, that's Form SH11, with the ROC. After that, there's a strict 6-month cooling period where you are completely frozen from issuing the same kind of shares. And the big overarching rule, the whole process has to wrap up within 1 year from the date the resolution was passed. While we're tracking dates, do not forget the critical accounting hook mandated by Section 69. If a company uses its free reserves or the securities premium to fund the buyback, an amount exactly equal to the nominal value of those bought back shares has to be immediately transferred to the Capital Redemption Reserve or CRR account. This is a super important step to protect capital, and trust me, it always sneaks into the practical exam problems. Section 5. Strict buyback prohibitions. The absolute legal don'ts. Now we turn to Section 70, which is basically the ultimate gatekeeper here. The Registrar of Companies is totally uncompromising. You cannot backdoor a buyback indirectly through a subsidiary or an investment company. No way. And even more importantly, you are completely barred from buying back shares if you have any subsisting, meaning ongoing default. We're talking defaults on deposits, debentures, or dividends. Got a term loan with a bank and you're in default? The law says you absolutely cannot use your cash to buy back shares. It makes total sense, right? Pay your actual debts before you start rewarding your shareholders. Section 6. Common exam pitfalls. Testing your application. All right, theory time is over. Let's apply these rules to some classic scenarios drawn straight from our question banks. Here's a direct exam question. Let's say XYZ unlisted company confidently passes a special resolution in a general meeting to buy back 30% of its own equity shares. Based on what we literally just covered, what is your immediate legal ruling? If you remembered our limits rule, you'd know this proposal is instantly invalid. Under Section 682C, the law strictly caps any equity buyback at 25% of the total paid-up equity capital in a given financial year. It honestly doesn't matter one bit that they properly passed a special resolution. They just cannot override that statutory 25% limit. Okay, let's twist the scenario exactly like the ICAI does. What if the directors realize their mistake, lower the buyback limit to 20%, but then they decide to fund this buyback using the proceeds from an earlier issue of the exact same kind of equity shares? Does that fix the problem for them? Your answer has to be that the proposal is still not in order. As per the proviso to Section 68(1), while you can definitely use proceeds from other specified securities, a buyback of any kind of shares can never, ever be made out of the proceeds of an earlier issue of the same kind of shares. Finally, keep this statutory quote as a golden rule for your exam prep. No offer of buyback shall be made within a period of 1 year from the date of the closure of the preceding offer of buyback, if any. Basically, once a buyback closes, the door is legally padlocked for a full year before another offer can be made. So, lock in those timelines, structure your answers clearly, and go ace that corporate law paper. But before we wrap up, think about this. If a company buys back shares just to artificially inflate its earnings per share, are they actually creating real value or just financially engineering their way out of a bad year? Let me know what you think. See you in the next explainer.